Welcome to The Explainer. Today, we are going deep on something that affects pretty much all of us every single day. It's that trap that's hiding in plain sight in the contracts we sign and the websites we use, the dreaded small print.
Come on, you know you have. We've all been there, right? You're faced with this absolute wall of text and you just think, yeah, whatever. Scroll to the bottom and click I agree. But have you ever stopped to think what you're really agreeing to? Because buried in that legal jargon are these things called exemption clauses. And trust me, they can have some pretty huge consequences.
Okay, so let's break it down. What is an exemption clause? Well, put simply, it's a line in a contract where one side tries to wash their hands of any responsibility if things go wrong. They're basically trying to put in a rule that says, hey, even if it's our fault, you can't sue us. They're trying to get out of being held accountable.
And honestly, some of them can be pretty shocking. I mean, get a load of this. A clause might actually say this. So imagine you slip on a wet floor in a shop because they forgot to put out a sign. This clause is their attempt to just say, too bad, not our problem. Wild, right? So what this really boils down to is a classic showdown. On one side, you've got this big idea called freedom of contract, the principle that people should be free to agree to whatever terms they want. But on the other side, well, as the famous legal scholar G.H. Tradle points out, that freedom is often a total illusion. I mean, when it's a giant corporation versus you, there's no real negotiation going on. They hold all the power and you're just left with a choice. Take it or leave it.
So how did the law start to deal with this abuse of power? Well, long before Parliament stepped in with new laws, the judges, the courts themselves, decided to fight back. And they got pretty creative, developing what you could almost call secret weapons to protect the little guy. The judges basically set up this three-part obstacle course that any exemption clause had to clear. First hurdle, was the clause even a real part of the contract in the first place? Second hurdle, is the wording specific enough to actually cover what went wrong? And the third and maybe biggest hurdle, is this clause trying to let someone off the hook for a complete and total failure to deliver what they promised?
To clear that very first hurdle, the legendary judge Lord Denning argued that you have to be given fair notice. He came up with what we now call the red hand rule. He basically said some clauses are so outrageous they'd need to be impossible to miss before you could be held to them.
So, how does a clause actually get into a contract? Well, it's usually one of two ways. By notice, a sign on a wall, or text on a ticket. And that has to be shown to you before you're locked in. But the really dangerous one is by signature. The general rule here is incredibly strict. If you sign a document, you are bound by what's in it. Period. It doesn't matter if you read it or not. Your signature is your bond.
But, even that super strict signature rule has a breaking point. And the best way to explain it is with this fantastic story about a stained wedding dress. So this woman, Miss Curtis, takes her dress to the cleaners, and they ask her to sign a piece of paper. She asks, "What am I signing?" And the assistant says, it just means we're not responsible for any damage to the fancy beads and sequins.
But of course, that wasn't what it said at all. The clause was a total blanket exclusion for any damage whatsoever. So when the dress came back stained, the company pointed to her signature, and the court said, absolutely not. Because they had lied about what the clause meant, they misrepresented it, they couldn't use it. A huge win for common sense. Okay, on to the second judicial weapon. It's a fancy Latin phrase, contra proferentem. All this really means is that if a clause is vague or confusing, the courts will read it in the way that hurts the party who wrote it. It's basically the law's way of saying, look, if you want to take away someone's rights, you better be crystal clear about it. No funny business. And what about that third hurdle, fundamental breach? Well, this is for those times when what you get is so completely different from what you paid for, it's not even funny. The classic case here is about a ruined Buick. A guy inspects a car, sees it's in mint condition, and agrees to buy it. But on delivery day, what shows up is a total wreck. The thing wouldn't even run, and get this, the bumper was literally tied on with a piece of rope.
The company actually tried to hide behind an exemption clause, but Lord Denning basically said you can't agree to sell a car and then deliver a pile of junk. As he summed it up so powerfully, the courts were doing everything they could to fight an unfair fight. But even they knew these tricks and workarounds weren't going to be enough. A bigger, more powerful solution was needed.
And that's when Parliament finally stepped in. The judges had done the groundwork, they'd shown where the problems were. Now it was time to create clear, powerful laws to deal with unfair terms once and for all.
You can really see the evolution here. First, you had that common law era, where the judges were using their secret weapons. Then, a huge moment in 1977,
the Unfair Contract Terms Act, or UCTA for short. And then things got even better for us in 2015 with the Consumer Rights Act, the CRA, which created a whole new rulebook just for consumers.
And this, right here, is probably the most important thing to understand about the law as it stands today. It basically splits the world in two. There's one set of rules for contracts between two businesses, and a completely different and much stronger set of rules for contracts between a business and a regular person, a consumer.
This chart lays it out perfectly. Now, one thing is an absolute non-negotiable under both laws. A company can never use a clause to get out of being responsible for causing death or personal injury because they were negligent. That's just completely forbidden. But for everything else, the tests are different. For a business-to-business deal, a clause has to be reasonable. But for a consumer deal, the test is higher. It has to be fair. And those two little words make a world of difference. So what does reasonable actually mean when we're talking about two businesses? Well, the courts look at a whole bunch of stuff. Were the two companies on a level playing field? Did one company get a discount for agreeing to the risky term? And a really big one, who is in a better position to get insurance for the potential loss? It's all a very pragmatic balancing act.
But for you and me, well, the game completely changes. The Consumer Rights Act gives us something called the gray list. It's basically a list of terms that are almost always going to be considered unfair. We're talking about things like massive penalty fees if you're late on a payment, or a term that lets the company change the whole deal or jack up the price after you've already signed up. This list is a massive shield for consumers.
Okay, wow. We have covered a lot of ground here, right? From old school judges with their secret weapons all the way to modern consumer law. So let's just boil it all down to the key things you really need to remember.
Which brings us right back to the big question we started with. After all of this, after all these legal battles and new laws, is the small print actually powerless now?
Well, not completely, but its power has been seriously limited. So here's the bottom line. First, freedom of contract isn't a blank check. It's always limited by fairness. Second, the whole story of this area of law is about one thing, evolving to protect the weaker party. Third, those old judge-made rules still matter. Courts can still toss out clauses that are hidden or confusing. But here's the most crucial takeaway of all. The law gives you, the consumer, way more protection than it gives a business. So the next time you see that wall of text, just remember this. Just because a company writes something down in a contract, that doesn't automatically mean it's the law. And knowing that, that's your first and your best line of defense.